Welcome back to the Emily Show and welcome to 2025. For those of you that just found the Emily Show podcast through my coverage of the Blake Lively, Justin Baldoni, it ends with us. It starts with litigation, lawsuit. Don't worry, we're going to be talking about that more a bit today. A few things that we have to cover today. Yes, the trilogy of lawsuits regarding It Ends With Us. Yes, Alec Baldwin is back in legal headlines because he is suing the prosecutor from the Rust case and more. I have that complaint. I'm going to give you the high points. We're going to break that down more thoroughly later this week. So make sure you have the Lawnerd app at lawnerd.com. So if you want to stay in the loop with what I'm covering on the live streams Tuesday, Wednesday, Thursday, you can. And if you just want the summaries, well, you know where to be right here on the Emily Show and on the Quick Bits channel on YouTube. And because attorney Alex Spiro has no chill, not only is he in the news with the Baldwin case, but the judge had a few things to say to him in the Jay-Z case. And yes, that Jay-Z civil litigation with Diddy is in fact a civil litigation against Jay-Z and not between attorneys Busby and Spiro, but we're going to be talking about the lawyers just a little bit more because the court told them all to knock it off. And well, we've got to cover it. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. Also, just a quick reminder for anyone who's new, everything is timestamped in the description down below. So let's talk Alec Baldwin. For all of you that followed the Rust trial along with me live, well, you know that on day 3 of the Rust prosecution of Alec Baldwin, the case was dismissed after a full day of hearings, and it was a wild day in court. The court dismissed the Rust prosecution against Alec Baldwin that stemmed from the fatal shooting death of Helena Hutchins on the movie set of Rust in 2021 because of the prosecutor's withholding of evidence. And in that hearing, which is summarized, and we will link all those summaries down below, the prosecutor, Kari Morrissey, actually took the stand in that case to talk about the evidence. Kari Morrissey clearly did not see it the way that the court did. When the court dismissed that case, she gave a very thorough and detailed written opinion after the fact, explaining why this violation of discovery rules, this Brady violation, warranted the extreme remedy of dismissing the prosecution. That was dismissed with prejudice, meaning the prosecution can't be brought again. It didn't stop special prosecutor Kari Morrissey from trying, because she then appealed that ruling. And the court was like, what are we even doing? Kari Morrissey has since stopped the appeal process and withdrawn the appeal, but that was also a fairly drawn out process that I covered filing by filing. Now, Alec Baldwin has filed, and Baldwin is not just suing Kari Morrissey. So in the complaint obtained by me, I love it when the media is always like, in a complaint obtained by people. Yes, obtained by me. I obtained it too. In a complaint obtained by me, we can see in 73 pages what Alec Baldwin is so upset about. But he's not just suing for the prosecutorial misconduct that a lot of you asked about when this case got dismissed. Like, hey, is he going to be able to sue for something like malicious prosecution? What are we going to see here? And we have the answer of what they are suing for. Baldwin filed this lawsuit in Santa Fe, New Mexico on January 9th, 2025, not just against Kari Morrissey, the special prosecutor here, but against Kari Morrissey, Mary Carmack Altwies, who is the elected prosecutor, Andrea Reeb, who is the prior special prosecutor, Jennifer Macias, the first judicial district attorney's office, which is going to be a difficult one, Alexandria Hancock, the lead investigator here, and Marissa Popple, who was the crime scene technician who testified at trial before the case got dismissed, Brian Brandel, and the Santa Fe County Board of County Commissioners. Everybody. The complaint is for 6 causes of action: violation of rights under 14 U.S.C. 1983. Those are the civil rights violations. Conspiracy to cause a violation of rights under 1983. Malicious abuse of process, which is what you would think of with like a malicious prosecution cause of action. intentional spoliation of the evidence or destruction of evidence. Spoliation is just all of the legal words. Defamation, which is interesting. Violation of New Mexico Civil Rights Act, which is going to echo the violation of the federal civil rights acts in that 42 USC 1983. So what exactly are they saying here? Well, in the introduction, they lay it out pretty clearly. The highest duty of all who investigate, charge, and prosecute criminal cases in the state of New Mexico is to fairly and impartially apply the state's awesome powers. And by awesome here, they mean the overwhelming power of the state or government. Criminal prosecutors are to be guided by the search for truth and justice, not to pursue personal or political gain or harass the innocent. They go on to say for the better part of the last 3 years, defendants repudiated these obligations, blinded by their desire to convict Alec Baldwin for all the wrong reasons and at any cost for the October 2021 accidental shooting death of Helena Hutchins. Defendants' misconduct in their pursuit of Baldwin and the trial judge's condemnation of them has already drawn worldwide attention, but this action is necessary to vindicate Baldwin's right and deter defendants from attempting to do this to anyone else. They say from the moments defendants and their agents set foot on the scene of the incident, it should have been apparent that Baldwin had no culpability. Minutes before, a member of the crew handed him a prop gun and loudly called out "cold gun" to assure Baldwin and everyone else present that it had been inspected and contained only non-explosive dummy rounds. Unbeknownst to Baldwin, the prop had been loaded with live rounds that looked similar to dummy rounds. The prop fired a live round and killed Helena Hutchins. They say defendants sought at every turn to scapegoat Baldwin for the acts and omissions of others, regardless of the evidence and the law. They go on to say that it includes Special Prosecutor Kari Morrissey, who wanted to teach Baldwin, quote unquote, a lesson because she deemed him to be a quote unquote arrogant prick. And yes, that is what they wrote in their legal filing. Then they go on to talk about what Judge Summer said in her dismissal of the case. When you are looking at malicious prosecution's case, you need to have the case resolved in the favor of the person suing. So the fact that this was dismissed in Baldwin's favor allows him to bring that cause of action. The defamation action is interesting because a lot of this is going to be covered by litigation privilege. These are things in the course of litigation, but are things said to the media going to count? Or is Spiro opening a door to where lawyers can be sued for defamation when talking about a case that is in active litigation? And if so, is Spiro opening up his own can of worms in the Jay-Z case because he has hurled some very strong allegations at the attorney in that case, Busby? So I'm interested to see that they are bringing a defamation argument against Kari Morrissey and others based on things they said in the course of the litigation here. It seems like this might end up being a double-edged sword for Alex Spiro. And no, the defamation cause of action is not for prosecutor Kari Morrissey allegedly calling Alec Baldwin an arrogant prick. It is against the elected district attorney, Carmack Altwies, and the prior special prosecutor, Reeb, R-E-E-B, and says that they made false and defamatory statements of fact concerning Baldwin, and to the extent any of their statements can be considered matters of opinion, such statements implied the existence of defamatory facts as described below. They say on January 19th, defendant elected DA Carmack Altwies appeared on CNN and discussed, quote, key pieces of evidence with a reporter from the Santa Fe, New Mexican. During the program, the elected DA asserted that Baldwin, quote, had a duty to make sure the set was safe, and he, quote, should have checked the gun, checked those projectiles, falsely implying that Baldwin was responsible for Helena Hutchins' death. They go on to say that on January 19th, 2023, the two prosecutors appeared on Jeannie Piero's program on Fox News, stating that, quote, it was not a safe set, and asserting that it was Baldwin's responsibility to ensure the set's safety, again, falsely implying that Baldwin was responsible for Hutchins' death. When I break this down further this week, it's going to be very interesting to explore not only the areas of where there will be immunity with regard to this lawsuit, but how litigation privilege is going to play in with these defamation claims, and whether or not you could look at the defamation claims and said, clearly, if someone was shot on set, it was not a safe set. And are they talking about Baldwin as an actor? Are they talking about Baldwin as a producer? It will be interesting to see how this litigation plays out, because there are such different causes of action, from malicious prosecution to civil rights violations to defamation. I've not seen a defamation case brought like this against attorneys successfully, especially when they are talking about a current litigation, but we will see. And to keep Spiro in the conversation, we need to talk really quickly about Jay-Z. You'll remember that the attorney for Alec Baldwin is also the attorney for Jay-Z. And so the attorney, Alex Spiro, who is taking shots at attorney Busby, the attorney for the anonymous plaintiff in the Diddy Jay-Z civil suit, they have been fighting with each other nonstop. I've outlined it in other breakdowns, and we are going to have to talk more about it this week. But the judge finally said, for now, the plaintiff will be allowed to proceed anonymously, and you need to chill. Directly speaking to attorney Spiro, you need to calm down. This is a ton of filings. They don't match the rules. These are not helpful. They are just attacks on the other attorney. Stop it. So what we are seeing in federal court and what we are seeing in New Mexico court from Spiro in the past and now is basically the same level of shade and spice. The federal judge, however, has less of a tolerance for it, saying, since Carter's, and that's Jay-Z's, since Carter's attorney first appeared in this case 17 days ago, he has submitted a litany of letters and motions attempting to impugn the character of plaintiff's lawyers, many of them expounding on the purported, quote, urgency of this case, describing plaintiff's counsel as self-promoting and accusing him of extortion, requesting to be heard on an expedited basis and accusing plaintiff's counsel of exploiting the legal process to generate media attention, asserting that plaintiff's counsel seeks only to benefit himself, requesting the shortening of a deadline from 21 days to 1, describing plaintiff's counsel as willing to, quote, blatantly violate the core ethical obligations of all attorneys, and requesting a hearing on a motion the following day. The judge goes on to write, Carter's lawyers' relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. The court will not fast-track the judicial process merely because counsel demands it. Moreover, although Carter's attorney assails plaintiff's lawyers as having a chronic inability to follow the rules, Carter's counsel has failed to abide by this court's clear rules. And then the judge goes to lay out which rules Spiro has not adhered to in this court. So while that type of blustery language was not smacked down in New Mexico earlier on in the Rust case, the federal judge in the Southern District of New York is not playing with any of this and has asked everyone to knock it off. That didn't stop Alex Spiro from filing a motion for sanctions against attorney Busby, and I'm going to break that down this week, but a request for sanctions has been filed. I am sure it is the first of many. And then we need to talk about the It Ends With Us litigation trilogy. For those of you who watch my longer form and live stream content, you will know that I tried really hard to summarize these 3 lawsuits and ended up covering 2 of them in over 7 hours. Yes, I streamed for 7 hours. Why? Well, I got very involved in breaking down all of the text messages and the who said what to who about whatever. The trilogy of lawsuits is essentially this, as best as I can summarize it. There is a lawsuit filed by Jonesworks PR. Jonesworks PR terminated one of the PR agents who is still working with Baldoni, who is in the other lawsuits as well. And upon terminating that PR agent, took their work phone and forensically downloaded it, among other things. Jonesworks and the lead PR agent at Jonesworks says that there was a negative media campaign run by the 2 PR agents still working for Justin Baldoni and Wayfarer. And the negative PR campaign run against Jones personally and Jonesworks was to drive a wedge between Jones and Jonesworks and their clients and to steal clients Baldoni, Wayfarer, and others. And that negative PR campaign was successful in damaging the reputation of Jones and of taking clients Wayfarer and Baldoni. That lawsuit also sues Wayfarer and Baldoni for not paying out their contract to the tune of $25,000 a month through May of 2025, as well as a lot of employment litigation causes of action. What will be interesting and what I am keeping an eye on in that cause of action is whether or not Baldoni and Wayfarer will countersue about a breach of confidentiality or breach of non-disclosure in disclosing the text messages to Lively's counsel and the New York Times, because that is where those came from. The attorneys for Baldoni and Wayfarer say that that was not a proper subpoena in other litigation. So when I say this is a trilogy of litigation, they all inform each other. Going through the entirety of the Jonesworks litigation helped me understand better the way that they are alleging this PR campaign went down. But also within the Jonesworks litigation, we saw some of the text messages from the Blake Lively lawsuit that is now filed in New York federal court being used to say, hey, these texts are talking about Jones. In the Lively litigation, they're saying, hey, these texts are talking about Lively. And then in the Baldoni against the New York Times lawsuit, it seems that in that threaded text message, they are in fact referring to Lively. But there are some very clear text messages in the Jonesworks lawsuit between the other PR agents, Melissa Nathan and Jennifer Abel. There are clear text messages between them talking about leaving Jonesworks, taking clients with them, and those conversations. It will be interesting to see what the documents bear out in that employment litigation suit, but it gives a lot of context for what was going on behind the scenes and for what Jonesworks says was a negative smear campaign against her. So the PR lawsuit in state court in New York is lots of employment, but also breach of contract. And I think we'll see a countersuit there about the disclosure of the text messages from PR agent Abel. Then we have the Baldoni Wayfarer et al. Lawsuit, including those PR agents as plaintiffs, against the New York Times for defamation. The lawsuit against the New York Times for defamation and other causes of action is filed in California. Do I think we'll see a countersuit there? No. Do I think we will see a lot of early litigation with regard to either jurisdiction or an anti-SLAPP motion? Yes. An anti-SLAPP motion cuts off discovery in a case and says, hey, I have a right to the thing that I am doing, the speech, and you are not likely to win your defamation cause of action. Will an anti-SLAPP litigation take out the knees from the contract causes of action there? Unlikely. So we could see the New York Times go two ways. A, say, come sue us in New York, or B, say, this has to mostly be dismissed. They are also suing for breach of contract, saying that, hey, the New York Times said they weren't going to publish this thing until noon. They published it at 10. We were damaged in the time from that 10 a.m. publishing to the noon publishing. The New York Times is going to say, we said respond by noon. You responded at 2 a.m. and we took that as your response. So we published it early because you responded before the noon deadline because you responded at 2 a.m. That seems to be what is lined out in that extensive litigation that took me hours to go through because there are so many text messages. The litigation from Baldoni against the Times lays out Baldoni's side of the story. I think they probably say Blake Lively's name in that litigation more than they say the New York Times, because they are attacking her story, saying that the New York Times just relied on her, and their reliance only on her story, given that they had all the text messages and emails that they said they reviewed, is showing that they knew that Lively's story was false and they ran with it anyway. Thereby, they argue, making the New York Times liable for libel. So does that lawsuit serve multiple purposes? Yes, it does. It responds to some of the things in Lively's lawsuit. It lays out Baldoni's side of the story, and it says, look, the New York Times should have known and evaluated all these things to see that Lively's side of the story is not true And our side of the story is vastly different. They are alleging, which we have seen reported in the media pretty widely, that Lively was not harassed in any way on set. She was not retaliated against, that there was no negative PR campaign or smear campaign. And in fact, it was Lively's PR person who went on a smear campaign, and they included a bunch of screenshots of conversations between Lively's PR representative and a reporter for the Daily Mail. Baldoni's legal team also says that the truth here is that Lively took over the project. Lively took the movie away from Baldoni and Wayfarer, and Lively was using the allegations of harassment to extort and leverage Baldoni to take over the film, take over the editing of the film, not allow him to be at the premiere, etc. So that is the allegations in that suit, couched as, and the New York Times should have known this, they didn't share the truth. They knew the truth. That's defamation, and there are damages. So we have the PR lawsuit. We have the New York Times defamation lawsuit filed in Los Angeles. And then we have the federal lawsuit that Lively filed, which largely mirrors the complaint that I covered on this show before the break over the holidays. The federal lawsuit filed by Lively lines out similar allegations that we saw in the complaint published by the New York Times: harassment and retaliation. This movie was largely filmed in New York. It's interesting to me that she chose to file the labor law complaint with the California Civil Rights Division in California and file this in federal court in New York, and that Baldoni chose to sue the New York Times in California, where the anti-SLAPP is pretty strong. I wonder if the attorneys evaluated the shield laws for reporters in New York and thought that they were stronger there and that discovery would be more difficult in New York, thereby filing it in Los Angeles. I'm very curious about the jurisdictional decision made to file in LA versus file in New York, and then Lively's team choosing to file in New York instead of filing in LA. There is much legal wrangling happening here. There is also much allegations and shade. All of these lawsuits point the fingers at each other. The head of Jonesworks PR, Jones, is saying, they went on a smear campaign to steal my clients and damage my reputation. Here's all the text. Blake Lively is saying there was harassment on set. I brought it up repeatedly. I brought it up numerous times. We had a meeting. We went through a 30-point document to say this can't happen on set. They signed off on it. We resumed filming, and then they retaliated against me in the press when I went on the press tour. Baldoni's side is saying the New York Times know that this is two very different sides of what happened here, and they ran with that this was harassment and retaliation, and they had evidence to show them that that wasn't true, and that's defamatory. Where do we go from here? Well, there's going to be likely a countersuit in the New York federal case against Lively. The attorney, Brian Friedman, for Baldoni and Wayfarer, has been very outspoken in the media saying, look, this is the beginning. It starts with litigation, it ends with litigation, and we're not even close to done. You get a lawsuit, you get a lawsuit, everybody gets a lawsuit. He put in the lawsuit against the New York Times that rest assured, this will not be the last lawsuit. It's in the lawsuit. The lawsuit promises more lawsuits. And he has said numerous times that he will be suing Blake Lively. He's intimated that he will be suing Ryan Reynolds and others. So we will see how many more lawsuits we will get to. And if they drop next week, as I am streaming, well, we'll be changing topics of what we are streaming on next week, which is why you need the Law Nerd app. But there will be more lawsuits here. Do we know whose side is right, wrong, indifferent? Well, the internet has a lot of opinions about it. I come from the perspective of all of these lawsuits leave me with a lot of questions. I want to see how those questions get answered as we go forward. It, for me, is not about picking sides. We are way too early in a litigation to know how this is going to shake out or what we are going to see. The parties and their lawyers know way more than the public does at this point, and everybody has chosen to sue. There is going to be a lot of discovery. I want to hear from the people on set. I think if this ever goes to trial, that what's going to be most persuasive is what the script supervisor has to say, what the other actors have to say, what the representatives from Sony who got looped into the middle of all of this have to say, because Lively said there were repeated requests for HR remedies with regard to harassment on set. If that is the case, that will be documented, and those documents will come forward in discovery and in depositions. If that's not the case, then that will also come forward in discovery. Baldoni says everything that happened on set is normal for what happened on set, that it is part of what we expect to see on set, and that nobody came into Lively's trailer without being asked. In fact, she said, "I'm in the trailer pumping, come on in. Here's the text message that says that." And if there are other people in Lively's trailer and makeup artists removing makeup, then they will be able to say, this is what happened on this day versus this is what happened on that day. Everyone else on that set is going to be instrumental in this trilogy of lawsuits because they are the perspective a jury is going to want to hear from. They're the perspective I want to hear from. These two sides, Baldoni and Wayfarer and Lively, are going to be locked at horns with completely different perceptions of what happened on this set. I'm very interested to see what everyone who got stuck in the middle of making this movie has to say. We're not going to see that for a while. We're going to see a lot of back and forth legal filings. I'm going to keep covering them. All I ask of the community and the law nerd community and those of you that are new to this community is try to embrace the I have questions attitude with me. Ask the questions of both sides. Keep your mind open to questions from both sides. And let's evaluate the facts and the law as we go forward here to see what we see. I have been very surprised of the way things come out in cases. It's why there are times I really enjoy watching how trials unfold without watching all the litigation before trial, because there are always things that surprise me and you go, well, that changes everything. I'm waiting for those moments here. The filings that we have right now are filings that are written by the parties in the light most favorable to them. These are written in the spirit of advocacy and the spirit of saying, I'm right, the other side sucks. That's how each of these complaints are written. That's how all complaints are written. These complaints just have a fuck ton more screenshots than we see anywhere else. I am very interested to see the rest of it. And Baldoni's side has said they're going to put up a website with all of the receipts. I'll be interested to see it. And then we can go through what the court will go through. Maybe we will see everything that the New York Times evaluated and be able to say, can the New York Times come to the conclusion they came to and write the article they wrote in light of the evidence we think that they had at the time? Is it their opinion? Can things be interpreted multiple ways? Look, text messaging is all fun and games until it ends up in a lawsuit. And then whatever sarcasm, humor, inside joke you thought you had is going to be taken by lawyers and looked at in the light least favorable to you. Litigation is adversarial. Each side is going to fight against the other. And we're going to keep asking questions. And look, I'm here for the shade. I want to see what these parties have to say. I want to see the rest of the text messages too. Let's just see it. It's all in the public now. There's no putting the shit back in the horse. Let me know which of these three stories you are most interested in following, because there's going to be a lot of spice in all these litigations because these lawyers do not hold back. And look, these lawsuits are being written so that they are easy for us to break down, and so they bring the public into the story from their side. And I'll keep looking at it. This has been the Emily Show Monday edition, new for 2025. The Emily Show will come out every Monday on the Quick Bits channel on YouTube and on your audio feed, wherever your favorite podcast is found. This is where the Emily Show lives now. And I will be streaming Tuesday, Wednesday, and Thursday on the Emily D. Baker YouTube channel. And I hope to see you there as I break down all these documents in the long form version, because 73 pages from Spiro regarding Baldwin is going to be very interesting to go over together. Thank you for being here. Thank you for being a law nerd. May the odds be ever in your favor, and I will see you in the next one. Bye. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a law nerd.